There's a story that the fossil fuel industry likes to tell, and has told the world for decades. In this particular tale, fuel companies are like pawns on a chessboard, moved by a hand that they cannot control. This hand, the invisible hand of the free market, conspires to bring coal, oil, and natural gas into factories, where they transform into the lifeblood of civilization. In this story, climate change is a boogeyman, a trick of the light powered by the imaginations of a few nitpicks who unfairly accuse corporate activity when a million other culprits exist. Without the services provided by enterprising, magnanimous businessmen, our world would stand still and return to darkness. But in California, a group of fishermen have started recognizing the dissonance between this narrative and the reality of their declining fortunes. Formerly skeptical of environmental groups, in the past few years, higher temperatures in the ocean have shortened the fishing season, reduced the harvest, and stirred algal blooms that threaten their catch. Fishermen and their families have seen their source of living dissipate. Many have had to sell their boats in desperation. Others have had to find temporary jobs in between the seasons. Recognizing that fossil fuel companies are behind their plight, they launched a lawsuit to hold them accountable. This lawsuit was filed in California Superior Court against 25 oil companies. It alleges 5 common and state tort law actions, including nuisance, failure to warn, and negligence. This particular lawsuit relies on a growing mountain of scientific consensus regarding the causes of ocean warming and acidification that threatens the ecosystem that these fishermen rely upon. Currently, parties are locked in a procedural delay. They have jointly requested that the proceedings be postponed pending the completion of other lawsuits against fossil fuel companies lodged mainly by cities, including Oakland and San Mateo. Once these cases go through the finish line in the Supreme Court, then this lawsuit will proceed. The science is clear and well established. Factory activity from fossil fuel companies emit both heat and carbon dioxide. The ocean, the world's largest carbon sink, absorbs both of these to detrimental effect. First, it creates the ideal conditions for algae to bloom. Increased algae leads to increased concentrations of domoic acid, a neurotoxin that they produce that builds up in the ecosystem through a process called bioaccumulation. Bioaccumulation is when bigger animals build up higher concentrations of a toxic substance by eating a large mass of smaller animals. In this instance, smaller creatures like clams, mussels, and sardines consume the algae and the domoic acid that they produce. The Dungeness crabs further up the ecosystem consume these smaller creatures and absorb the domoic acid into their bodies to the point of harmful and lethal toxicity. This is what disrupts the harvest and the fishermen's economic activity.
Let's take a minute to examine the historical context to these cases. Climate litigation has been steadily increasing since the 1980s. It's exploded recently, with hundreds of cases filed in just the last few years. But the vast majority of cases have been based on federal statutes or constitutional or state laws, with only 28 out of over 1,400 cases based on common law, where the tort cases come in. And if we filter down to those common law cases, almost all of them are cities, counties, or states suing big oil companies. In the last 4 years, there's only been one case brought by individual citizens rather than a government. This one. Why is it so significant that this is the only private case? We'll get there in a second. First, let's hear a little bit about the case from the plaintiffs themselves.
My initial reaction was just like a lot of other fishermen. It's like, well, I have a diesel engine in my boat, so why would I want to sue a fossil fuel company? I'm reluctant to be part of something that might anger a lot of my fellow fishermen. But in the end, you have to stand on principle that you believe in. I mean, I that's what I was taught, and so I believe it's the right thing to do.
The deep regulatory capture of federal agencies and representative bodies, the extent to which they have bought and paid for policy, basically co-opting democratic institutions in order to get their agenda furthered. I mean, that feels different in this instance. It feels like it's been effective beyond anyone's wildest dreams.
That's right. You just heard a commercial crab fisherman discussing deep capture. That's one of the things that's so striking about this case. It's private plaintiffs from a traditionally conservative demographic. Why is that so important? Well, first, they're going against the grain. Psychology expert Dale Miller tells us that if people believe an in-group member is disrespecting the group's values, people in the group will experience moralistic anger. That's something you heard Ben talk about, fear of angering his fellow fishermen. Now, as John Jost tells us, people are motivated to believe that the institutions, authorities, and arrangements on which they depend are good, fair, desirable, and legitimate. Members of the working class are especially prone to system justification biases, as are more conservative individuals. So again, here we have the last people we would expect to sue against the status quo, conservative working class individuals, doing just that. That indicates something important. The fossil fuel industry has lost legitimacy among its most reliable support base. Now, it may not surprise you to hear that the industry has lost legitimacy and that loss is reflected in this case. But loss of legitimacy might not be enough to make a difference if the legal system stops any momentum in its tracks. This brings us to the more important question: can the fishermen win? Let's ask an expert.
You know, it's hard to say. I was looking at the docket, and it looks like they've just sort of been in this holding pattern for a couple of years. It's not surprising that big oil companies are trying to use every type of procedural mechanism to make sure that these cases don't get heard. You know, it might be difficult to say that a fossil fuel company is responsible for a poor Dungeness harvest in 2017, but I think that there are many ways to argue and prove that the fossil fuel industry is responsible for a certain share of the climate change that is happening across the world.
Let's hear from someone else.
The civil discovery system is so powerful. And so once it gets to discovery, the parties in the case, the litigants, the jury, but also it serves a democratic function of the public at large, learn something about potentially products that have presented a danger and conduct that has been wrongful toward all of society. So I think that if a case gets to discovery, that things will start to unravel for the industry.
Ultimately, the Dungeness crab case is a litmus test for tort law's ability to grapple with the existential crises of our time. In the face of overwhelming evidence and the global alarm bells over the increasingly narrow prospects for humanity, can tort law flexibly subsume climate change into its ambit and hold corporations accountable? Can the increasing scientific consensus, which conclusively traces responsibility many steps into the causal chain, finally convince judges and enter into jurisprudence? Can plaintiffs, finally shocked out of their system affirmation by the realities of economic decline at the hands of fossil fuel companies, use tort law to obtain reparation for the damages these companies caused to their livelihoods? Or will tort law remain an ossified artifact, incapable of moving with the times and every bit as vulnerable to capture as government regulation?